Hello friends, today I am going to discuss another important judgment recently pronounced by the Honorable Supreme Court of India on 24th of October 2024. This judgment would help us to understand what are the various conditions under which the gift deed can be revoked or cancelled. And what I will be doing is I will take you through the facts of the case and various timelines associated with the journey of this case from the trial court to the Supreme Court, and we will understand what was the question of law before the Honorable Supreme Court, how did the Honorable Supreme Court arrived at the final conclusion, and obviously in the end we will also discuss what was the final conclusion, whether the appeal was allowed or dismissed or it was allowed in part. So let us now get deeper into this matter to understand the facts of the case and the timelines. In this matter, the appellant is the original defendant in the property suit and has approached the Honorable Supreme Court after receipt of the dismissal order from the Honorable High Court. Whereas the respondent, who was the original plaintiff, who has filed the suit for declaration of its title over the suit property as well as recovery of the possession of the property. So let us go very briefly into the timelines of this matter. What has happened is that around 1983, a gift deed was executed between the appellant and the respondent. Subsequently, in 1987, this gift deed was revoked through a revocation deed. Obviously, the initial plaintiff, which is now the respondent in the matter, it filed the suit, and whereas the trial court actually dismissed the suit on two accounts. One was that the deed not valid as not accepted by the respondent, which is the plaintiff, initial plaintiff, as well as because there existed a revocation deed. However, in 1997, when the appellate court was approached by the respondent, which was the original plaintiff in the matter, the appellate court reversed the judgment of the trial court and decreed the suit in favor of the original plaintiff. Aggrieved by the decision of the appellate court, the appellant, who is the defendant, has filed the second appeal before the Honorable High Court, and that appeal was dismissed on the 11th of January 2011. Now, upon receiving the dismissal from the second appellate court, that is the Honorable High Court, the appellant, who is the defendant in the matter, has approached the Honorable Supreme Court and filed its SLP. The leave to appeal was granted after condoning the delay of 207 days. And now we have a judgment for this SLP in which the Honorable Supreme Court has addressed the key issue that what are the various circumstances or the conditions under which a gift deed can be revoked. So let us now get deeper into the question of law framed by the Honorable Supreme Court in this matter. The question of law has two aspects in this matter. One is whether this registered gift deed dated of 1983 was duly acted upon and accepted by the respondent in the matter or not. This issue, this portion of the question of law is more in relation to the actual facts of the matter, whereas the second issue, which is going to be more pertinent for us to understand, is that whether this gift deed, which is now 1983 document, whether this document is a valid document in view of the revocation deed which was executed subsequently in 1987. This was the question which will help us to understand what are the various conditions under which a gift deed can be revoked. So let us now understand the analysis of the Honorable Supreme Court and enrich our knowledge with the various aspects, with the various pointers which will help us to ensure that the stakeholders can appropriately understand the law and use it as per their requirement. To get an answer to the first aspect of that question, that is whether the donee, that is the respondent, has accepted the gift deed or not, let us get into first the various conditions present in the gift deed itself. The gift deed, no doubt, it was a registered document. However, the conditions in the gift deeds were that the donor has gifted the suit property only for the purposes of manufacturing of khadi, lungi and khadi yarn, etc. So the only purpose for which the donor has gifted this land or this property to the donee, that is the respondent, for the purpose of manufacturing of this khadi lungi and khadi yarn. Another condition was that the respondent or the plaintiff, who was the original plaintiff, will not transfer the suit property for its own interest. Third condition was that the donor or his legal heirs will have no right and will not continue to have any right or interest in the suit property from the time and date of the gift deed. And finally, a very important condition is that the date of gift deed itself, the PF, that is the plaintiff for the respondent, accepts the suit property for the use which is mentioned above. So now, in view of the conditions disclosed in the gift deed itself and the various other facts of the matter, the Honorable Supreme Court held that deed is valid for want of the acceptance. The trial court rejected the suit itself, disclosing that deed was not accepted by the donee, that is the plaintiff. Therefore, the suit was rejected, whereas the Honorable Supreme Court held that the deed, it was validly accepted by the plaintiff or the respondent in the matter, because that the gift deed itself states that from the date of the gift deed, the suit property is accepted by the plaintiff or the respondent. And other factors or the facts which came before the Honorable Supreme Court was that the plaintiff and the respondent had applied for the mutation to the revenue authorities. The plaintiff has also obtained the possession of the property and it proceeded to raise the construction thereon. So, in view of these facts as well as the conditions of the gift deed, it was held by the Honorable Supreme Court that the gift deed is valid for the want of acceptance. So, now let us come to the second portion of that question, whether in view of the revocation deed dated 1987, is the gift deed dated 1983 is now a valid gift deed or not. So, in view of the revocation deed, the Honorable Supreme Court also tried to understand that if the gift deed is now invalid, what would be the impact upon the rights of the plaintiff respondent in respect of the suit property. That was also a part question framed, but you will get to know the answer of this question soon. Now, the key observation of the Honorable Supreme Court in the matter in relations to the gift deed was that the gift validly made can be suspended or can be revoked under certain contingencies, but ordinarily it cannot be revoked, more particularly when no such right reserved under the gift deed. So, this is the guiding principle, but from where this guiding principle is coming from, let us go and understand the Transfer of the Property Act section 126. Now, this section discloses the conditions under which the gift deed can be revoked. As per this section, when gift may be suspended or revoked, there are three conditions in this section. The first condition is where the donor and donee agree for its revocation on happening of any specified event. But we must remember that this specified event should not depend upon the will of the donor of the gift. So, if in the gift deed there is a condition that on occurrence of some event which is depending upon the will of the donor of the gift, then the gift deed can be revoked. Let us go to the second condition. A gift which the parties agree shall be revocable wholly or in part at the mere will of the donor, is void wholly or in part as the case may be. For example, if the gift deed discloses that the gift deed would be void wholly or in part as per the will of the donor of the gift, then this gift deed itself is a void wholly or in part as the case may be. The third important condition for the revocation is that the gift deed may also be revoked in any of the cases in which, if it were a contract, it might be rescinded. So, when the gift deed is in the nature of the contract, then only there is a mechanism under which the gift deed can be revoked. Apart from these three conditions, the gift deed cannot be revoked. So, applying these principles, the law as per this section 126 of the Transfer of Property Act 1882, the Hon'ble Supreme Court came to the conclusion for this question. The answer was that the gift deed which was validly made could not have been revoked in any manner. So, the Hon'ble Supreme Court held that this revocation deed is void ab initio. Although the gift deed was having one purpose, that the donor has gifted this suit property only for the purpose of manufacturing the particular kind of products, but in the gift deed there is no such clause that if the donee did not perform the actions in accordance with the gift deed would liable to be revoked. Since there is no stipulation in the gift deed that if suit property is not so utilized, the gift deed would stand revoked or would be revoked at the discretion of the donor. So, in absence of this revocation clause and applying the principles as per the section 126 of the Transfer of Property Act, the Hon'ble Supreme Court held that the gift deed is a valid public document and the revocation deed which was subsequent to the gift deed cannot revoke the gift deed dated 1983. Thus, the appeal filed by the defendant of the original suit was dismissed and the Honorable High Court order was upheld by the Apex Court. I hope this video would have helped you to understand the various conditions required for revocation of a gift deed. And if you like this video, please share this video with your friends, colleagues or other stakeholders for which you think that this new judgment would be helpful. And thank you very much for going through this video. Jai Hind.